Palworld is the kind of idea that sounds so simple you're surprised nobody did it sooner. It's a game that's had a lot of labels since the trailer released. Rust with Pals, Cartoon Arc, and most prominently, Pokemon with Guns. Put plainly, it's a survival crafting game in a world full of sentient animals that can be captured and used to help fight enemies and build bases. It's the kind of project that wears its influences on its sleeve, and to be honest, it's a pretty good time, especially if you have some friends to play with. The game struck a chord with people when it launched, receiving overwhelmingly positive reviews on Steam and a peak player count of over 2 million players. In fact, the game was such an immediate success that Pocket Pair spent the first month or so scrambling to get more servers spun up to accommodate the sheer number of new players. But, for as good as the game is, that isn't the part I find the most interesting. You see, this video is not about Palworld, at least not directly. This video is about what happened 5 days later. Palworld launched on January 19th, 2024. On January 24th, Nintendo announced that they were looking into potential legal action, which they would deliver on September 18th later that year by filing a patent infringement lawsuit in the Tokyo courts, seeking the equivalent of $66,000 in damages and an injunction against selling the game in Japan. Compared to the estimated $400 million of revenue, the damage sought is shockingly low, though at this point I do need to provide the disclaimer that as of the time of this writing, the lawsuit is unresolved. The actual numbers could vary quite a bit depending on the final judgment. There are 3 patents involved, which we'll dig into later, and you may be wondering why I, as a US citizen and not an expert in Japanese patent law in any extent, am paying attention to a lawsuit half a world away. The reason is that Nintendo has also filed for the same patents here in the US, so US patent law makes a good framework to use when trying to wrap our heads around what's going on. A major key to the whole situation is understanding the differences between a patent, a copyright, and a trademark, because those differences actually raise some interesting questions. Of the 3, trademarks are probably the easiest to understand, so we'll start there. According to the US Patent and Trademark Office, PTO for short, a trademark can be any word, phrase, symbol, design, or a combination of these things that identifies a company's goods or services. Some topical examples of trademarks would be things like the Game Freak surfboard, the Pokemon font, or Pikachu's face. It could even be something like Relaxosaurus here, since the design is the Steam icon for Palworld. Look at him, he's perfect. Not a single thought in that head. Even the Just Graham coffee mug is a trademark with how consistently I use it across my channels. Trademarks are only enforced locally until they're registered with the PTO, at which point they get enforced nationally. Copyrights are easy to understand on paper, though their consistent presence as a hot-button issue on YouTube would suggest otherwise. Copyrights are legal protections designed to protect creators from unauthorized use of their artistic expression. According to the US PTO, copyrightable works include literary, dramatic, musical, and artistic works, such as books, plays, music, lyrics, paintings, sculptures, video games, movies, sound recordings, and software. Though that protection does not extend to ideas, procedures, processes, systems, methods of operation, concepts, principles, or discoveries. The current stance of the PTO is that while specific expressions of an idea are protectable, the underlying idea itself is not. If you've ever wondered why things like the 50 Shades of Grey novels or James Cameron's Avatar are allowed to exist, that's why. The law also makes exceptions for things like criticism and education, which are important elements of the artistic process. An important thing to note is, given the list of things that aren't covered by copyright, and the fact that ideas behind the artistic expression are not protectable, game mechanics can't be copyrighted. Patents are where things get tricky. While the USPTO is able to explain trademarks and copyrights in simple language, they've not been able to do the same for patents, so I'm going to do the best I can. Put plainly, a patent is a legal protection for an inventor that protects others from making, selling, or importing an invention. There are 3 kinds of patents that an invention can fall into. Design patents protect the ornamental design of manufactured products, plant patents cover new strains of plants, and utility patents cover everything that doesn't fall into the other 2 categories. According to the USPTO, patents protect processes, machines, manufactures, and compositions of matter. They go further to define a process as a mode of treatment of certain materials to produce a given result. It is an act or series of acts performed upon the subject matter to be transformed and reduced to a different state or thing. What makes patents hard to follow in regards to video games specifically is this is a place where the law has not kept up with technology. Ask yourself what should be a simple question. Are game mechanics patentable? They aren't a machine manufacture or composition of matter, and while they are a process by the normal definition, they don't really fit the definition provided by the PTO. With the criteria given, the answer should be no. Things are rarely so simple though, and some game mechanics have been patented in the past. From what I was able to find through my research, the actual answer in practice seems to be that game mechanics can only be patented if you can find a judge who is willing to approve it, or if the mechanic itself relies on new technology. Now that we have at least a simple understanding of what a patent is and isn't, let's dig into the details. There are 3 patents in particular as the focus of the lawsuit. JP 2024-054400 and JP 2024-149570 are similar patents that deal with a method of determining an aiming direction and allowing the player to release an item or combat character in that direction. And JP 2024-055978 relates to seamlessly shifting between mounts depending on whether the player is in the air, on land, or in the water. One thing to note is that while all 4 are marked as 2024 patents, they're offshoots of ones that were granted back in 2021. So, despite appearances and a lot of early reporting, the lawsuit does not actually involve patents that hadn't gone through the process at the time of the lawsuit. Looking at the patents themselves, the first 2 both seem nearly impossible to avoid when you set out to design a creature capturing game. I can't read Japanese, so the diagrams themselves are beyond me, but the actual language of the patents is written in broad, generally applicable terms with a lot of room for interpretation. In fact, depending on your point of view, the Needler from the Halo games would potentially violate parts of the patent if it hadn't come out 20 years earlier. And that fact actually forms the basis of Pocket Pair's defense. A common defense against patent infringement lawsuits is demonstrating other examples that use the same principles or technology to show that the original patent shouldn't have been granted in the first place. To that end, they assembled a list of dozens of other games that have the mechanics that the lawsuit concerns. The more that they can prove to the court the mechanics in question are less a novel invention than part of the common language of game design, the more likely the court is to throw out the suit. As an additional step, they've also made changes in-game to the question mechanics to help sidestep the worst of it. With an understanding of what the actual issue is, what's at stake here? I mentioned earlier that the damages Nintendo is seeking equal only $66,000, so I feel comfortable saying that this is not an issue of money. Instead, this is a purely business move through and through. Both US and Japanese law is precedent-based, meaning that the court's decision is going to be heavily influenced by what it determined in the past. It's much easier to win a case if you can point to a similar one that ended in your favor. A victory for Nintendo in this case not only means that the patents will stand, but also that it'll be that much easier to take the next creature capturing game that releases down. Something that actually happened while I was working on this very video. While I haven't heard of Nintendo making any moves in that regard yet, I'm sure it's only a matter of time. After all, Nintendo has a history of using their patents to go after their game's competitors. There's also another angle to this that, while unconfirmed, makes too much sense for me to not mention it here. With Palworld's meteoric success, they reached out to Sony to help bring the game to an even wider audience and spin it into a multimedia juggernaut. The very same Sony that's been Nintendo's stiffest competition since a blown deal in 1992. While it's purely speculation at this point, it's certainly believable that this lawsuit in particular is intended more to take a shot at Sony than having anything to do with Pocket Pair and Palworld. As for Pocket Pair's side of things, I'm not sure how much a loss here would actually impact their business. Yes, Palworld is by far their most successful game, but they've been moving more towards the publishing side of things for a while now. With some good business sense and an eye for talent, publishing can be a very lucrative business, and they'd hardly be the first developers to make that move. Of course, this lawsuit doesn't only impact the companies involved, it also impacts everyone who enjoys games. And here's the part where you're gonna think that I'm a Palworld fanboy who just cares if my team wins, because I believe that Nintendo needs to lose this suit for the good of the industry. Game design is an iterative art form. Everything that exists is built on what came before when it comes to genre and mechanics. There are examples all over the industry. What are games like Call of Duty or Battlefield without a Doom to create the FPS genre? Would Balatro exist without something like Slay the Spire to catapult the roguelike deck builder genre to popular success? Every great game, every cool idea is taken by the developers inspired by it, and spun off into something new which inspires the next generation. There's a quote that's often used, and possibly incorrectly attributed to Bruce Lee, that says, "Absorb what is useful, discard what is not, add what is uniquely your own." And that is at least as applicable in game design as it is in martial arts. So where are we left if patenting game mechanics becomes common? You can't use a patented invention without negotiating a license from the patent holder. And as an aspiring game developer myself, I worry about walking into a patent I wasn't aware of more than is probably healthy. If it was something you really had to consider whenever you sat down to make a game, how many games would we miss out on because the devs wouldn't even bother to try? Or worse, because they want to try, but can't afford the license. It wouldn't just affect indie developers either. In a recent interview with Den Faminio Gamer, Fumito Ueda, the director of Ico and Shadow of the Colossus, wondered, if we are no longer in the era where we need to provide new devices or new game mechanics every single game. Even if the mechanics are not new, you can focus on the feel and the art. Think back over all the AAA games you've played over the last several years. I'm willing to bet you've played some really good ones, maybe even ones you've enjoyed enough to introduce to a friend. Now, think about how many of those were really innovative. Game development has gotten impossibly expensive over the years, and companies are not willing to risk keeping their game from being a hit. Would they take on the added risk and expense of licensing the use of a game mechanic from a competitor? I'm willing to bet the answer is no, because no one bothered to license the Nemesis system despite the incredible potential it had. The Nemesis system was created for the Shadow of Mordor games as a way for enemy captains to become recurring minor enemies with an evolving personality based on events that happened in-game. It was a smash hit idea that got players' minds spinning with the possibilities. Naturally, Warner Bros. Entertainment secured a patent for it, which ensured that it was only ever used in 2 games before they closed the studio behind the system earlier this year. That patent expires in 2036, at which point anyone who wants to explore the idea can. I don't know if they will, though. From what I was able to find, Warframe and a few undisclosed racing games implemented similar systems, though the ways that they had to twist it to avoid infringing on the patent poisoned the idea for a lot of people. And that's where things sit for now. With the suit still ongoing, there's only so much information we have at the time of recording. I don't know what the future holds, but I will be keeping a close eye on these things. For now, though, I need a break. There won't be another video at the end of September, but be sure to come back in October for a fun, supersized video I'm cooking up. Halloween's always a great time on this channel, and this year should be especially great. Catch you then.